Thank you, Mr. Chairman. I thank all the witnesses for your perseverance here today, too. This is a relatively long hearing for us, and I picked up a lot sitting here listening. I wanted to make a point here and then move on to a broader one, and that's this, that some years ago I went through an exercise of what is Congress obligated to do under Article 3, and this has to go back to about 1802 when there were a couple of federal districts that were abolished by Congress, court districts, and I happened to read through all that debate, and so I began to ask this question. What we're obligated to do under Article 3 is produce a Supreme Court of the United States. And we could, conceivably, abolish all of the federal districts, and the only thing left would be the Supreme Court, and the only obligation we have there, since it calls for a Chief Justice, is to have a Chief Justice, but we don't have to fund the building or his staff. He could be at his own card table with his own candle. That's what Congress is obligated to do. And so I would suggest that the Article 3 is pretty limited if Congress decides to assert its power and authority over it. If nothing else, the workload would stack up on Chief Justice Roberts. And so that was just an exercise in constitutional discussion, more or less kind of metaphysics. And so I just went down through Article 2. Since the President's usurping Article 1 authority, what does the President of the United States have under Article 2? And I went through a number of these things here. He's the Commander-in-Chief of the Armed Forces. Congress forms the Armed Forces. They may not exist, at least theoretically. He may require an opinion of the principal officers of each executive department. He may, but they may not be departments for him to require an opinion of. Then he shall have power to grant pardons and reprieves, and he has, with the advice and consent of the Senate, treaties and appointments, but then he's subject to the authority of the United States Congress. So in the end, the question comes down to, what enumerated powers does the President have independent of congressional approval? That turns out to be 6. He may pardon. He shall deliver the State of the Union. It's not an address. It might be in a letter, as it was under the earlier presidents. So he could send a letter to Congress and meet that requirement. He shall recommend legislation. Well, he does that without having to be prompted very much. He may convene Congress. He may adjourn, but so may Congress adjourn. So that's really not a power that's effective. He shall receive ambassadors and ministers. That means that the President then shall be the head of state and conduct the functions of a head of state, at least diplomatically. And the last one is, this wonderful one, he shall take care that the laws be faithfully executed. So when you look through that, the only two that have any power really at all is the power to pardon, which could be significant under certain circumstances, but the power and the obligation to take care that the laws be faithfully executed. And I don't know that I've heard an argument as to how the President might be doing that under the circumstances that we're discussing here today. Not only that, not only is he violating his own oath of office, it's very, very clear that he has said, I'm not going to enforce the laws that I don't want to enforce, and by the way, Congress, I'm going to recommend legislation to you, and if you don't pass that legislation, then I'm going to implement it by my executive edict. Not always executive order, executive edict. And I'm going to take care that the laws that I don't want to be executed are not, including the section that requires that those who are interdicted by law enforcement and immigration be placed into removal proceedings, shall be placed into removal proceedings, and we have a President who says they shall not. And he has ordered his executive branch to violate laws. And by the way, some of this is not under litigation in the court case we're talking about over the November 20th edicts, but it is under litigation in the Crane versus now Johnson case that was filed a couple of years ago, Crane versus Napolitano. So I'd just ask this question, and that is, what if Congress decided to usurp presidential authority? What if Congress decided, listen, the President's not doing his job, he's not keeping his oath, why don't we form a Justice Department and fund a Justice Department and direct and order a Justice Department? And I would ask first the question of Professor Foley, if Congress decided to do that, we could enforce these laws. And what would be the consequence of such a thing?
Yeah, it's a great question. I posed this before the last time I had testified before the committee on the President's actions with regard to Obamacare and delaying the employer mandate. And the hypothetical I posed is, what if the Speaker of the House decided he wanted to appoint himself Commander-in-Chief? right? But it's the same idea, right? What if Article 2, Article 2 can supposedly usurp Article 1, but Article 1 can't usurp Article 2? It doesn't work either way. I mean, neither one is constitutional. And the point about, this being prosecutorial discretion, just ask yourself, everybody I think on this panel agrees that the $6 million legal question on prosecutorial discretion is what the president is doing consonant with congressional will? Because you get to control your statutes and he has to faithfully execute them under the Constitution. So is what he is doing consonant with what you want and what you have directed pursuant to the INA? I think the answer is patently that it's not consonant with congressional will. And just as a thought experiment, again, ask yourself this. Why didn't previous presidents think they had the authority to do this? If this was so politically palatable for such a long period of time, for the last 30 or 40 years, why didn't President Clinton do it? Why didn't President Carter do it? The reason they didn't do it is because no president thought they had the authority to do this because they didn't think Congress had authorized it under the INA, which explains why the president went around 20-plus times and said he didn't have the legal authority to do this. And by the way, the Supreme Court has said as much. There was a case called Utility Air Regulatory Group versus EPA involving EPA's carbon tailoring rule that was decided last summer. And in that case, the Supreme Court basically said, look, one of the reasons why the carbon tailoring rule violates separation of powers, and it did violate separation of powers, is because the EPA is promulgating a regulation that flies in the face of years of understanding of what the Clean Air Act was thought to give the authority to the EPA to do as a regulatory matter. It's the same thing here. The same form of construction of Congress's will should take place in this case, too.
In the end, in conclusion, Mr. Chairman, it's the people that decide the division between the three branches of government, and I think they need to declare war on the enemies of the Constitution.
The gentleman from Ohio yields back his time, and the gentleman from Florida, Mr. DeSantis.